DF 22-04493 on a motion for enforcement and clarification. Councils, would you please state your name for the record?
Rebecca Rowan for the petitioner, Dr. Judith Kirby.
Lisa McKnight for respondent, Dr. Randall Kirby.
Okay. Attorney Rowan, you filed this motion. You may proceed with your opening statement.
Thank you, Judge. May it please the court. As you heard from us a couple of weeks ago, this is a petition for enforcement of property division as well as a request for clarification under Chapter 9 of the Texas Family Code. The parties had an agreed divorce decree entered by this court in November of 2022, ordering the husband, Dr. Randall Kirby, to timely pay all of the parties' 2021 personal tax liabilities. He's failed to do so, resulting in egregious interest and penalties that are accruing every month and are continuing to accrue. You're going to hear evidence today, Judge, that we have very real concerns about the respondent's burn rate and his spending habits. We do believe he has the funds to pay the remaining tax liability, because you'll see evidence that in September of last year, he received over $650,000 from the sale of the marital residence. But despite having the funds to pay the taxes, we are very concerned about his spending habits. So we are asking the court to enforce your own decree and order him to pay this debt. We're asking you to clarify that word timely and order it to be paid by time and date certain. Specifically, we're asking for you to order him to pay it by next Friday, April 4th, 2023. The short time frame is in direct response to the evidence you're going to hear.
Buckle up. This isn't just a divorce cleanup. This is financial fallout at its messiest. We're in Texas Family Court, where two doctors, Judith and Randall Kirby, are back at war after their 2022 divorce. The decree ordered Randall to pay the couple's 2021 tax bill, but he hasn't, and the unpaid debt is ballooning with interest and penalties. Judith's side claims Randall pocketed over $650,000 from the sale of their home but still ignored the IRS. Meanwhile, Randall's attorney insists he's already paid over $1 million in community debt and paints this as a $5,000 issue blown into a $19,000 legal circus. Add in accusations of reckless spending, threats of sanctions, and conflicting claims about abandoned requests, and this case has all the elements of courtroom chaos. Stay tuned, because what starts as a simple enforcement motion spirals into a battle of credibility, money management, and legal strategy.
About our concerns about his spending habits. So that's the first thing we're asking you to do today, Judge. The second thing we're asking you to do is to order the respondent to execute a release, releasing my client from a business line of credit that in the divorce decree, he agreed to take that debt and indemnify my client. She's still on as a guarantor and a signer on that business line of credit, and we're asking him to simply sign a release that she can then provide to the bank to get her off of that line of credit. That's the second thing we're asking you to do today. The third thing that we're asking you to do is order attorney's fees to be paid by the respondent on behalf of my client, because she had to file this lawsuit in the first place and bring it to the court's attention. And so you'll hear me testify in support of that request for attorney's fees.
Notice what Attorney Rowan is asking for here. 3 clear remedies. Pay the IRS immediately, release Judith from liability on a shared line of credit, and cover her legal fees. On paper, it's straightforward. Enforce the decree, protect the petitioner, and punish non-compliance. But here's where strategy kicks in. By asking for payment by next Friday, Rowan is trying to box Randall in before he can burn through more assets. It's not just about debt, it's about timing. Courts often struggle here. Is this about fairness, or about controlling a spouse's financial choices after divorce? That tension is at the core of what's unfolding.
I've looked at Ms. Rowan's requested relief today, and if she had started with that relief, that's some relief that we probably could have reached an agreement on. This is about a $5,000 enforcement case. That's it. And what she did was turn it into a nightmare, requesting relief that she's not entitled to. It's interesting that the relief she's wanting today is nothing like the temporary order and injunctive relief that she wanted in the past month. And so attorney's fees is an issue. I have filed and set today also a motion for Rule 13 sanctions, both against Dr. Kirby and her lawyer for pursuing this action. And so there's some facts that are going to come out. Since the date of divorce, you'll learn that my client has paid well over $1 million in community debts. There is a practice loan that is in both of their names that he's responsible for, that he's made payments for every single month. And there's approximately $180,000 owed on it.
Enter Attorney McKnight, and the gloves come off. She reframes this entire case as overblown, a so-called $5,000 dispute that Judith's lawyer has turned into a nightmare. Her weapon. Sanctions under Rule 13. This is bold, accusing the other side not just of overreaching, but of abusing the process. McKnight points out Randall has paid over $1 million in debt already and insists the IRS hasn't even begun collections. This is where courtroom drama really heats up. One side saying Randall is reckless with money, the other side saying Judith is weaponizing the system. It's a classic credibility war.
Hearing set on already is for him to have to put $400,000 into the registry of the court to cover the taxes that were owed, which were $175,000, and to cover this note, which is not due, for $180,000. What you're going to learn is that there has been zero collection efforts on the part of the IRS or this practice loan. There was it's about $1.1 million in taxes that were due. He's paid all of them, except now that there's $175,000 that is due. After the divorce, he's remitted $200,000. It was $365,000 was due at the time the divorce decree was entered. Okay. Now, so what she came to court asking for was that he had to put $400,000 into the registry of the court to try to collect 2 unsecured debts. She's very focused on the proceeds of the house, which he was awarded. And really what's the most relevant factor here, Judge, is that we've had a hearing.
Here's the numbers chessboard. Randall owed $1.1 million in taxes, has already paid around $925,000, and now sits on about $175,000 still due. Judith claims the penalties are spiraling monthly, while Randall's attorney dismisses that as flat-out false. This is a subtle but critical legal battle. Is this an urgent enforcement case because penalties are stacking up, or a manufactured crisis to pressure Randall? The judge will have to cut through the noise. And remember, money math in courtrooms isn't just accounting, it's storytelling. Each side is spinning numbers into a narrative.
Had a hearing set in August on the issue of ordering the proceeds of the sale to be used to pay the IRS. That was a pleading. I'm going to ask the court to take judicial notice of it. It was set for a hearing and we reached an agreement that subsequently, and we proved it up on the record, that subsequently got entered in the final decree. That agreement awarded him the house unequivocally and ordered him to timely pay the taxes. Okay. Now, so what we have, it's a tempest in a teapot. The man had owed a $1.1 million in taxes, and he now owes $175,000 in taxes. She's repeatedly said, and it's factually incorrect, that there's $17,000 of penalties and interest accruing a month. That is not true. There is no document that she has that will demonstrate that. He will pay 100% of the taxes. Today is the first day I got this purported release that she wanted signed, which he signed it already. If she had sent me this in the beginning of the lawsuit, I would have happily signed the release. Okay, that's not what she wanted. She wanted to accelerate the $180,000.
The conversation shifts to the business line of credit. Judith just wants off the hook as guarantor, and suddenly, Randall signs the release with no fight. Notice what just happened. A major point of contention dissolves instantly. That raises a question. Why did this even require a court hearing if Randall was willing to sign all along? This moment reveals how much courtroom battles can become about leverage and optics, rather than true disagreement. It also undercuts Randall's claim that Judith's requests were outrageous. If he can resolve this with a signature, why wasn't it done months ago?
Note, cram it down his throat, make him pay it off with the proceeds of the house, which she's not entitled to do. And now she's finally abandoned that claim. After we've had 2 hearings on this already, after we had to brief it to the court. And so what should be a $5,000 enforcement case, 1 motion, 1 hearing, is now a $19,000 enforcement case in a Rule 13 sanctions. And so that's the issue, is who's paying whose attorney's fees at the end of the day here. What's transpired is a travesty. She knows, or should have known, that's not appropriate relief to ask for. So the relief that we're having today is extremely watered down. It's basically, and I don't disagree. So what she wants is for you to clarify when he has to pay the taxes, okay, and clarify the amount. That's going to be real easy. The amount's $175,000, and so you're going to either decide when does he have to pay that. Our proposal is that the court set a report back in 90 days from today's date to see if he's complied with payment in full of the IRS taxes. Okay, the man has been paying taxes for all his life.
Now comes the high drama. McKnight doubles down, calling Judith's earlier requests egregious enough to trigger sanctions. In plain terms, she wants the court to punish Judith and her lawyer for even filing this case the way they did. That's a serious escalation, because sanctions aren't routine. They accuse the opposing lawyer of bad faith. But here's the irony. By attacking the petition, McKnight risks making Randall look combative and evasive. The judge must now juggle not just tax debt, but whether this legal war itself has crossed the line into abuse. This is courtroom brinkmanship at its finest.
He's never not paid the IRS. The relief she's wanting with respect to the other note, now it's just have him sign a release. Okay, done. We signed a release. It's basically the decree already released her from this, but that's not really what she wanted. What she wanted was you to force him to pay the whole note off. That's what she wanted. And that's why she wanted you to order him to put $400,000 into the registry of the court and not be able to spend any money on anything else until he paid that note and the IRS. That is so egregious as to rise to the level of Rule 13 sanctions. And that is also set before the court today. And those are the issues.
Thank you.
Judge, may I briefly respond since I'm the petitioner?
Sure.
Thank you. First of all, I object. I did not see a notice of hearing for the motion for sanctions being set for today. Ms. McKnight, if I'm incorrect and it's out there, please point it out to me and I'll certainly look for it. But I'll cite my objection to that going forward if it's not properly set. I take serious issue, Judge, with this allegation that I have somehow abandoned certain requests, that I have somehow watered down certain requests. Judge, I beg you, go look at—
Judith fires back hard, denying she abandoned claims or watered anything down. She distinguishes between her temporary injunction requests and today's final trial enforcement, insisting her core demands never changed. And she's got a sharp point. If these requests were so reasonable, why didn't Randall's side agree back in January? This is a credibility clash in real time. One side says the other is exaggerating, the other says the defense is playing revisionist history. And right in the middle? A judge who has to decide not just who owes what, but whose version of events actually holds water.
Get my petition for enforcement that I filed in January on this case. I asked for, at final trial, which is where we are, this is final trial, I asked for him to sign a release, to enforce the tax debt and order it to be paid by a time and date certain. Those are the same requests I pled for, and I'm asking you to do it today. Now, completely separate and apart from that, I had a request for temporary orders and temporary injunctions that was set before Judge Lee. We presented arguments on it. She indicated to us that she thought both sides had merit to the argument. And then we presented some of those arguments to you a couple of weeks ago. That is a completely separate and different issue that is a temporary orders request. So if somehow Ms. McKnight is trying to put those together and say, I'm abandoning claims and I'm watering down claims, that's not true. Those were my temporary orders requests. Today, we're set for final trial. So this is what I'm asking you to do. I find it really interesting that for the first time I'm hearing, we probably could have agreed to this. This was in my petition from day one, from January. If we could have agreed to these things that I'm asking you to do today, it certainly would have been helpful to hear that back in January and February when I first filed this petition and Ms. McKnight had a copy.
So where does this leave us? Judith demands Randall pay $175,000 in IRS debt immediately, sign away her liability on a business loan, and cover her attorney's fees. Randall's camp claims he's already shouldered massive debts, that Judith exaggerated penalties, and that sanctions should hit her side instead. What should have been a clean enforcement hearing turns into a full-on credibility brawl over money, motives, and legal tactics. At the heart of it, one big question: is Randall failing his obligations, or is Judith overreaching? What do you think? Should the court crack down on Randall's spending, or call out Judith's legal strategy? Drop your thoughts in the comments, hit like if you're hooked by this drama, and subscribe for more explosive courtroom breakdowns.
Of it. So to the extent she's now saying, oh, all my requests today are so reasonable and she would have agreed to it, then what are we doing here? Why couldn't we have settled that if she would have come forward to me and told me that? But be that as it may, I just wanted to clarify those particular points. I also take issue with the fact that Ms. McKnight is telling you what I was requesting and why I was requesting it. In my initial petition, I requested $400,000 to be put into the registry of the court because that was the total tax debt owing at that time. And then subsequent to my filing the petition, the respondent paid a $200,000 payment to the IRS. So it went from a $400,000 approximate tax debt number to about $175,000. And that's the number I'm requesting today. I was never asking you to put $400,000 into the registry of the court to be both the line of credit money and the tax debt. I was concentrating on the tax debt because that's the thing that's accruing interest and penalties. So I just wanted to clarify that for the court. I think that was everything that I wanted to say, Judge, and I'm happy to call my first witness.
Okay, thank you. You may proceed.
Thank you.
Oh, and Judge, on the issue of notice with respect to my sanctions, Ms. Roman, I have proof of service where you opened it on 3/24.
Okay, I'll go look at my emails.
Okay.
Attorney McKnight, I was just getting ready to mention that.
Okay.
Ms. Rowan, it is on file with the court. It was filed March 24th at 4:46 p.m.
Okay, thank you. Appreciate that, Judge.
You're welcome. You're welcome.
And I'll call the petitioner, Dr. Judith Kirby.
Okay, let me swear in both parties. Would you both, Ms. Kirby, Mr. Kirby, would you both raise your right hand? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do. Okay, say it again with the microphone.
Yes, ma'am.
Thank you. You may lower your hands, and Attorney Rowan, you may proceed.
Thank you. Will you please state your name, ma'am?
Judith Kirby,
And where do you reside?
Dallas, Texas.
What do you do for a living?
I'm an eye surgeon and ophthalmologist.
Do you own your own medical practice?
Yes, ma'am.
And are you the petitioner in this case?
Yes, ma'am.
Judge, permission to share my screen?
Yes.
2022.
What does your ex-husband do for a living?
He's a vascular and general surgeon.
And does he own his own medical practice?
Yes, ma'am.
And to the best of your knowledge and recollection, approximately how much income does he bring in each year?
As of through December of 2022, he was bringing in anywhere from about $3 million a year on average. That was filed October 17th of 2022.
Okay. Under the terms of your final decree of divorce, who was awarded the marital residence?
Randall Kirby.
And the day after your divorce, did Mr. Kirby receive a purchase offer for the house?
He did.
And did he accept that to the best of your knowledge?
Yes, ma'am.
I'm going to show you, has your ex-husband paid all of the 2021 tax debt that we saw reflected on P4?
He has not.
Did you start receiving notices from the IRS related to that unpaid tax debt?
Yes, ma'am.